Thanks for coming for this lunch seminar. I think today, we are very honored to have Dr. Li Xingyue over here. The last few days, we have already had quite a lot of lunch seminars, thanks to the events which were hosted by the Chinese University of Hong Kong. So I think we are very lucky here. Let me very briefly introduce Dr. Li. Dr. Li is an associate researcher at the School of International Law and a founding member of the Institution for International Law and Policy of Global Commons Governance of the East China University of Political Science and Law in Shanghai. I know this center, regarding the global common governance, we're looking to not only the internet cyberspace, we also look into outer space and other physical areas and the deep sea bed. So I think this has been a very important initiative by the School of International Law at the East China University of Political Science and Law. Dr. Li is also a part-time legal advisor of international operations at the Shanghai Island Law Offices. She is selected for 2023 Chinese National Overseas Talent Program, 2023 Shanghai Magnolia Talent Program Youth Project, and 2024 Shanghai Higher Education Young Teacher Cultivation Funding Scheme. Her current research interests include advanced multidisciplinary theories of international law, emergent economic security reconciliation, and multidisciplinary legal issues, science and technology innovations. She teaches science, technology, and law, public international law, international human rights law, and international law, moot court competition. She is a module director of the International Commercial Arbitration Case Study, which is part of the International Arbitration Law Master Degree Training Program of the Ministry of Education and the Ministry of Justice, jointly built by Shanghai International Arbitration Center, East China University of Political Science and Law, Fudan University, and Shanghai University of Political Science and Law. She serves as the coach of ICRC International Humanitarian Law Moot Court Competition. Today, she will talk about a quantum international law theories towards an inclusive international investment security construct. I think this is topic, is really something, is very new to me. So I very much look forward to hearing the presentation, the seminar. So now, without further ado, Dr. Li, you have the floor, please.
Thank you. Thank you so much for Professor Zhao for this very thorough and for a detailed introduction of me. And I felt a little bit embarrassed to overhear all of my titles and my personal experience. So I'm very much exposed here. Today, I think we're going to talk about a very new and a little bit complicated topic, which is titled the Quantum International Law Series. So thank you, everybody, for being here with me to join in this journey. So before we start, I would like to, let's look at the photo together. The background photo is captioned as, "In me, a tiger sniffs a rose." What does it mean? It means something drastically far apart and very exotic can actually come together and generate something breathtaking. So in the following 1 hour, within 1 hour, let's all together think about how quantum theory and international law can be joined together and create something breathtaking. So in the following years, there are two different kind of reorientations in the global economic, global foreign investment ecosystem. The first talk about the transition from international to domestic in the liberalisation continuum, represented by the global resurgence of the investment screening mechanism all around the globe, especially within the domestic investment law. So this has been widely discussed by scholars all around the globe, and this has become a very heated issue, especially with the second transition, which is the transition from legalization to politicization in what we call a geoeconomic order. And this has been very interesting because before, at the end of last century, the US-led global order has emphasized a neoliberal global order. And after the 2008 or the 2018, the US and China rivalry, we have seen this kind of shift within the global order, which talks about that we no longer want a neoliberal one, but a geoeconomic one. So what does geoeconomic actually mean? It means states, powerful states, engage in conflict by methods and activities of economic arenas. And so here, we really want to understand whether those two hypotheses are accurate and precise enough. And if not, how can we proceed from here? And how can those two hypotheses actually can guide our research and practice in a very meaningful way? So how to think about those questions? Then the key issues is really to think about the relationships about economic security risks and economic rewards. So the key point here is to navigate classical legal irreconciliations, such as investment security, which is focused talking about the relationships between investment and security with the perceptions and the methodologies aligned with current policymaking considerations. And the ultimate goal, I think, is actually within everybody's here, and we all think about how to ensure resilience and inclusion of the global economic order. Okay, so let's now think about why that is extremely difficult. In 2023, the WTO Attorney General actually announced that we are now living in the era of polycrisis. What does polycrisis mean? Leo, want to have a try? Leo, what does polycrisis mean? Want to have a try? So the last word, crisis, a lot of risk, right? What is poly? What is poly? Poly, what does it mean? 多重, right? Multiple. So this word has become a very hated word within the talk of WTO, which said that we live in a polycrisis era, and when everything, literally everything, have the fundamental features of complex, systematic, and cross-disciplinary. So let's think about the investment security as an example. When we want to think about investment security dynamic, it is highly linked with energy security, cybersecurity, highly linked with political atmosphere, highly linked with what we're talking about, the democracy, about human rights, about environmental protection, and even about the climate change. So all of those factors are actually coming together, working in the same systematic regime, which we call the global economic order, and even the global order itself. Welcome. And because the problem itself are very much complex, systematic, and disciplinary. However, in the international law school or in the law schools, we don't actually talk about how cross-disciplinary it actually is. So think about this. When any of the tutors or lecturers or professors teach you about investment security dynamics, they don't literally only talk about investment security in the field of international investment law, but we also teach students about international investment, international security, right, and etc. So everything is highly complex, systematic, and cross-disciplinary, meaning the way we try to digest this kind of question, we need to equip ourselves with a mindset that is already complex, systematic, and cross-disciplinary. So it is very, very extremely difficult, especially which my research focus on, is there are a lot of separations within the current existing disciplinary. So let's first focus on the border domain separation, which is between science and social science. After the 20th centuries, the social science has become more and more independent. And so now when we think about the social science, when we learn stuff in law school, we don't naturally go to talk about something in physics. We don't talk about something in mathematics, right? So that is a very problematic issue because before the 20th century, everything are kind of bridged together and they have generated a lot of fundamental inspirations for the contemporary social science. And the second separation, I think everybody work in international law are fairly familiar with, is the separation between international law and international relations. And when we doing research on international law, there are excessive neoliberal oriented the kind of mindset that we have to do international law based on a quite legal formalism mindset, meaning that the international law has to be fully independent and has to gain more and more autonomy when we talk about the issues in international law. However, because every security-related issues are quite politically sensitive, it means that if we fully abandon a really realistic theory or perspective when we're doing research in international law, then we've lost its audience within itself. And so because there are separations in the broader domain and the narrow domain, it has made us the way to comprehend a complex, systematic, and cross-disciplinary issues in a poly-crisis era more and more difficult. And this has led me to quantum theories. And this is interesting, right? So why quantum theories? This is because when quantum theory was firstly established in 1904, it has two different kinds of functions. First, as physics mechanics to inspire our current scientific and technology advancement. Second, this is an interesting one, to become a philosophy, to become a metaphysical assumption that can enlighten humans' endeavors in intellectual exercise in social science. So even before quantum theories, let's all think about Newtonian's classical physics. So Newtonian's classical physics talk about the two fundamental laws. The first, everything has its fundamental laws. As long as we follow such a pattern, we're going to have certain outcome, right? That is Newtonian's classical physics. The second rule of Newtonian's classical physics, I think everybody here is quite familiar, is the reality is made up by energy and matter. So this means part plus part equals to the whole. And those have become the metaphysical assumptions which have led to the establishment of what we call the classical social science. For example, we think about sociology. Sociology is actually built upon the concept that humans are working and live atoms in the society. So that's why the contemporary sociology is established. And in the meantime, Adam Smith proposed economics works under the principle of an invisible hand. So meaning that as long as the market follows an invisible hand principles, it will reach certain outcome. And let's think about it further. Karl Marx also proposed that the communism will naturally arise after the capitalism of his time. And in the meantime, we'll also see psychology, which is a kind of nature science process in action in the field of social science. So all of those exercises, all of those mainstream social science are what we call the classical social science, which are built upon the foundation of the Newtonian's classical physics. Then in the recent century and the last centuries, the quantum theories has become widespread and more adoptions in physics, science, and even social science. And I think everybody here understood this very, very, very famous stories about the Schrodinger's cat, which means there is a box of cat within, and before we actually open the box, the cats within the box are both live and dead in the same time until we open the box and make the observation. And so after the widespread of quantum theories in social science, especially in 2015, there is a rise what was called the quantum social sciences. So scholars are trying to use quantum theories to enlighten our exercise and mindset within the field of social science. For example, 2015, the Alexander Wins has established a scholarship called the Quantum International Relations. And in the meantime, we also have quantum cognitive decision theories, quantum finance, quantum economics, and quantum security. And all of that are quantum social sciences that are trying or at least have the potential to revolutionize the whole field of social science. And how about law and the international law itself? So in 1989, the scholars are trying to equip quantum theories within the field of law. However, until today, even though there are a very small strength of scholars are trying to use quantum theories in the field of international law, specifically by using the uncertainty principles, which kind of aligned with what we said we live in a polycrisis era. But there is no one actually trying to comprehensively to extrapolate quantum theories from physics to the field of international law. And this is the gap that I want to fill. So let's look at a how-to theory of the quantum IL theory. And this is a little bit difficult and complicated. So the first thing that we need to do is trying to pick 3 fundamentals within the quantum theories that can really make sense in the field of global economic order. I picked 3. First, entanglement, second, measurement, and third, holism. So let's look at the first one. The first one is quite ironic because Einstein once criticized it as spooky action at a distance. So this is a photo extracted from the 2022 Nobel Prize winner, which actually proved the existence of quantum entanglement in laboratory. Okay, let's look at this closer. The particles 1 and 2 are a pair. Particles 3 and 4 are a pair. And because 2 and 3 are in an entangled status, so whenever 1 move and change, 4 move and change, even though they don't actually link with each other and they don't have any kind of relations with that we can observe with naked eye. So this entanglement has highlighted everything is kind of entangled and interwoven with each other within the polycrisis era. So what is measurement? Measurement means the particles or the realities constantly move within the wave function. And if we observe it from a certain position, it will collapse into one single outcome. So it was again criticized by Einstein as God does not play dice with the universe, but actually, as it turns out, God always plays dice with the universe on a daily basis. And this has highlighted the potentials of probability within the reality. And it also highlighted uncertainty of the reality as well. And the third one is quantum holism. Quantum holism suggested that parts are the approximately abstraction of the whole. So what does this mean? Let's look at the photo here. The structures within the small balls resembles the structures of the whole ball. So if we think about Newtonian's classical physics here, Newtonian's classical physics suggested that part plus part equals to the whole, right? That is what we can understand because the whole can be reduced into its fundamental constituent. However, according to the whole part relations suggested by the quantum holism theory, part approximately equals to the whole itself. So this can be a little bit counterintuitive, but this is why quantum theory can revolutionize or can transform our understanding of current international law theory. Then the second thing to figure out is through what kind of approaches that all of those fundamentals can be applied to international law. And I pick out 3, as I call them trinity approach. So the first is analogy approach. Analogy approach is to borrow metaphors and analogy from quantum theory, right? To illuminate solving legal problems. So it more often use narratives like A is like a quantum system. One of the examples is made by Lawrence H. Tribe in 1989. So he published an article in Harvard Law Review, which is called What Lawyers Can Learn from Physics, where he used Heisenberg's uncertainty principle based upon the quantum measurement theory for constitutional jurisprudence. So this can be understood very easily because it's just making analogies and metaphors, which are adopted by law scholars on a daily basis. The second one is a little bit advanced and more challenging for us to understand because it's trying to use quantum theories through an ontological approach. So the narratives is A is or look as an actual quantum system. And it was only established by Alexander Wynne, Chen Pan, Carey, and O'Brien through their exercise of quantum international relations after 2015. And it will largely challenge the traditional ontological, epistemological, and normative underpinnings of international legal studies. And finally, the post-critic approach is what we're very familiar with because can be viewed as a critical legal study method. So we use quantum theories to criticize existing case studies, existing jurisprudence, and existing scholarship. Combine three of them together, it constructs the trinity approaches of quantum international law theories. So let's think about where can the theory make contributions to? How can they actually help the existing mainstream legal studies? Can it actually replace or substitute all of other theories? So basically, there are three assumptions here. The first is it can work as the theory for everything, meaning that there can be one ultimate theory for international law and policy. And the third one is nihilistic theory for everything, meaning what we're all doing here is pointless and we don't have to do international law. All the international law never makes sense. So what I'm trying to prove here is the quantum international theory is actually one of the theories for everything, meaning there is no ultimate theory of international law and policy, but rather a compilation of increasingly precise theories operating as complements rather than substitutes to offer practice or reference within the given limit. So after what we first is construct the quantum international theories, let's now try to do some tests on it. The first test I would like to do is upon the first hypothesis I mentioned at the beginning, which is the transition within the investment security ecosystem, which suggests that we are undergoing a transition from international to domestic in the liberalisation continuum, which is represented by the resurgence of global-wide investment screening mechanism within the domestic law. So first, a very easy one is to use quantum entanglement through the analogy approach. And here it suggests that the investment security dynamic is like a quantum entanglement, meaning that it's conditioned in both economic and political values and interests. So through this exercise, it discloses two deficiencies of the hypothesis. So it suggests that the hypothesis one fails to integrate multiple narratives structured by non-legalistic and non-liberal perspectives. And in the meantime, the hypothesis also overlooks potentials for multidisciplinary breakthroughs in integrative thinking. So that is through the use of quantum entanglement through the analogy approach. The second one is to use quantum holism through ontological approach, which suggests that investment security dynamic is a quantum system, accounting for the whole population with the holographic nature. So it suggests that on the one hand, the part, which is the investment security dynamic, is approximately identical to the whole, which is the economic security regimes in the global economic and the political atmosphere. And this requires to engage in depth with the paramount challenges of the traditional normative foundations that economic security regimes face. And on the other hand, it also suggests that the part is not completely identical to the whole. So this requires to answer zoom-in questions, such as what does international and domestic investment law actually means, and what are their hierarchies. And lastly, by using post-critical approach, we critically reflect upon the hypothesis one throughout. So it concludes that though it contributes a neutral conceptualization, it necessitates a targeted theoretical framework to clarify how to understand the national security protection in international and domestic law. And a very funny part here is in variation A, And the post-critic approach is applied throughout. So you can see the blue part covers all. And we want to highlight the all-encompassing capacity of post-critic approach. And in comparison, in the next variation, variation B, we see the green part. The green part covers all, meaning we want to highlight the strength and depth of a quantum worldview through the ontological approach. So here, as the premise, we suggest that investment security dynamic is actually a quantum system, sharing all quantum features within its whole part polygraphic relations. And because the investment security dynamic already is a quantum system, so we can adopt a lot of its theories through ontology, analogy, and the post-critic approach as you wish. And so, for example, I use quantum measurement here as an analogy, which suggests that investment security dynamic emerges as a shared wave function that passes through state practice and owns negative and positive potentials. And it again disclosed the two deficiencies of the second hypothesis, which talks about the transition from legalization to politicization in what we call a geoeconomic order, including the negative assertions of delegalization and politicization is neither exclusive to geoeconomic order nor empirically supported. And also the international investment arbitration does not necessarily guarantee the depoliticization of the disputes, because diplomatic and political engagement remains very essential for the ISDS. And lastly, and we use post-critic approach again to critically reflect upon given hypothesis, and it suggests that actually to advance those kind of hypotheses, we need to synthesizations of insights from diverse disciplines through the trinity approaches, and rather than simply adopting mainstream discourses or ideologies. And in the end, the quantum-based integrative thinking will most likely to develop a more accurate understanding of contested issues. So those are what we conclude through the application of variation B on the hypothesis second. So after the test, let's all think about this together because it can be a little bit difficult for us to understanding. What in essential is quantum international law theory? It is, frankly speaking, a very rudimentary theory building effort. So it is a way to try to rethink and reimagine what is investment security construct. So I propose that there are three things that we can do at the current stage is first, we use quantum theories as analytical tools through the analogy approach to comprehend complex, systematic, and multidisciplinary concepts and values. And second, we can use quantum ISO theories as a kind of methodology or scholarship through the ontological approach, which will help us to identify ways that international law can be ontologically reimagined and reconstructed. And through the third approach, we can use the post-critic approach as a kind of critical legal thinking methods. So it will help us to advance and develop the critical legal theories within the field of international law. And maybe perhaps more. What can be more? So, boldly speaking, as a theoretical framework, the quantum international theories or other very creative theories can may be adopted as preambles within the international agreement because it can highlight what are the relationships between different values. And we see the comparison of different values in all of the preambles of international agreement all the time. So maybe there is a chance that something can be both creative and have practical innovations. And build on that, it can start to de-bias decision makers. And because decision makers will need to think about more and more probabilities instead of certainties. And then it will start to support compliance and implementations of international law because it moves away from the rational theories and trying to let us all think about the initiatives, the willingness within the actors itself, which brings us back to the foundation, to the very core of international itself, which are the willingness of these actors. And lastly, of course, is about talent cultivation. And in all the law schools, we hardly see any scholars or any professors talk about how to use quantum theories or how to use physics, how to use mathematics to enlighten students' thinkings and students' exercise in law practice and etc. And so I really do think that the talent cultivations through this kind of approach may be a very inspirational way. But in the meantime, yes, I have been doing this kind of research for 4 years now, and I have received a lot of constructive criticisms. And most of the times it suggests that this can be a self-amusing exercise. And based on what Leo and I have a little discussion 10 minutes before the seminar, the talk, and we do agree that to convince such a very creative and novel research can be very challenging. So in the line of research, there are 3 criticisms that are very often. The first is, it is very much unnecessary because trawling through a weird theoretical route tends to overcomplicate the problem. So maybe it is not very desirable. And the second, because there are huge knowledge gaps among remote disciplines, so there is a chilling effect among all of the international law communities to actually adopt and accept certain theory. So it will have very limited impact at most. And the last one, of course, we all understand as lawyers and judges because it fails to provide a pragmatic recommendations for the day-to-day professional practice. So it is very much inapplicable in practice. But how do we proceed from here? Even though there are so much constructive criticisms, but during my 3 years of PhD studies, my series talks about international economic law and quantum theories, which mainly focus on how to use quantum theories to interpret geoeconomics and apply the whole theoretical framework to reconciliate between national security and economic liberalization. And as you can see, this exercise has been quite successful because there are 2 different kind of projects already being established, a conceptual one and a normative plus one. And the normative plus one has already been applied on issues including cybersecurity and also energy security. And you can find all of my publications online. And so even though there are a lot of criticisms and it may not have so many impact or applicability, but still I'm doing it and I am doing it just fine. And because this talk is actually hosted by the Center of Chinese Law, so I'm actually trying to brainstorm how that can be linked to Chinese law or in new settings. And so everybody understand that I was trained in Durham universities in the UK, and that's why I did the quantum international law theory. And now I moved back to East China University of Political Science and Law, and I know that things can be a little difficult, but as academics, we all need to adapt into our new and different environment. So those are the 3 questions I propose in articles written in Chinese. So basically, first, what are the differences between quantum international theories and the traditional international theories? And through this exercise, which is published by the Chinese Journal of International Economic Law, we can see that even though there are a lot of criticisms on the topic itself, and that most of the times there are very less open-minded environment, but it can be done. And the second issues talk about whether international law can be advanced through a quantum approach. So this is an article that I'm currently writing based upon my publication in Oxford Bibliography in International Law. And I suppose the last and high-level questions here, and I think I need more time and more interrogations and exchanges with Professor Zhao and everybody here, is how the quantum international theories can contribute a Chinese narratives of international law itself. So the key problems here is we do have the third world approach to international. And we do have what we call a US-led global economic order, But how can we actually try to advocate for our traditional or very good values within the law through a very subtle approach, such as quantum international theories? So those are the questions that I am trying to think and dealt with currently. And as I said, it is a very challenging path. And so I truly encourage everybody here, every students here trying to do creative innovations, because the only questions that we really need to ask is why we are here. Why are we trying to use quantum theories here? Because there are certain contexts right now, and there are certain goals that we want to reach. And so I think the value of quantum international law at the current stage is not about solving individual cases. It's not about serving lawyers and judges, but it's about to provide a fresh set of pluralistic approaches to understand the economic security dynamics for international law and policy, and also train our thinking in exploratory quantum-based ways. And lastly, let's recall again the picture at the background. In me, the tiger sniffs a rose. I truly believe that there are a lot of ways we can do things differently. And for me, in my personal life, my research and my teachings, I have equipped myself with what Nietzsche has said: you have your way, I have my way. And as for the only way, the right way, the correct way, it does not exist. So even though in the field of international law, we don't have a theory for everything, such as Stephen Hawking has spent his whole life doing so. But we do have a way to change the model we think. So let's all together change the model we think. Thank you.